Oh, Queen Justice, where are you? Did they beat you up or no? Lock you underground, take the crown away from you?
Oh, Lady Liberty, red, white, and blue. Did they take your dignity with their bigotry? Teach you that you're born to lose.
Free or guilty, it's gonna get filthy. Better believe, roll up your sleeves. It's gonna get rough, it's gonna be tough. We all agree, we've had enough. We've had enough
of all the rules you break.
We've had enough
of all the money you make.
We've had enough.
No more life gets taken.
We've had enough.
This is a proclamation.
It's been 400 years and we're 400 late. Together we stand from state to state. Going back in time won't make America great. We need justice now, people won't wait.
Action, no more distraction. Every step we take, we gain traction. If it can happen to one, it can happen to all. United we stand, divided we fall. Free or guilty, it's gonna get filthy. Better believe, roll up your sleeves. It's gonna get rough, it's gonna be tough. We all agree, we've had enough. We've had enough
of all the rules you were breaking.
We had enough
of all the money you were making.
We had enough.
No more life gets taken.
We had enough.
This is a proclamation.
Free or guilty, it's gonna get filthy. You better believe, just roll up your sleeves. It's gonna get rough, it's gonna be tough. We all agree, we've had enough. We've had enough
of all the rules you're breaking.
We've had enough.
All the money you're making.
We've had enough.
No more life gets taken.
We've had enough.
This is the proclamation.
We've had enough. Trayvon Martin and Tommy Rice. We've had enough. Michael Brown and Eric gonna pay the price. We've had enough. Philando, Breonna, George Floyd. What? We've had enough. So many gone. How can we fill the void?
How can we feel?
We've had enough. John Crawford, I know you've heard. We've had enough. Sandra Bland, come on and take a stand. We've had enough. Sean Bell, what the hell? We've had enough. Freddie Gray, did you hear what I said? We've had enough.
This is a proclamation.
Our discussion on the case, the trial, that has everybody's attention, everybody certainly here in Minnesota, I think everybody in the country and around the world, the case of the trial of Derek Chauvin, the former Minneapolis police officer who's on trial right now for the death of George Floyd. George Floyd was killed about a year ago, May 25th, I believe was the date. Derek Chauvin, one of three officers, or four, on the scene, but three that were directly involved in restraining George Floyd. George Floyd dies. The prosecution says as a result of the restraints placed on on George Floyd. The trial so far has focused again and again on the fact that Derek Chauvin's knee was on the back or neck of George Floyd for 9 minutes, maybe in 25 seconds. The prosecution rested its case yesterday, I believe. The defense rested its case today, and Monday, the summaries will take place. Well, I'm pleased to have, again, Dean Burnele Venable Powell, Emeritus Dean, retired from the University of South Carolina Law School, and my colleague and friend here in Minneapolis, Attorney Clinton Collins. He's corporate counsel for Geico Company, but he and I go back a long ways. He and I were both on the board of directors of the Minneapolis Urban League. I served as chair, and he did as well following me. We've had a business relationship as well, with Clinton being my corporate attorney. So thank you both for being here, Clinton and Professor Powell. In
Glad to be here.
disclosure, Professor Powell is my first cousin, and so we've known each other since we both were infants. So it's always good to talk to you, Burnele. How you doing?
I'm doing fine. We've known each other since before we knew that we knew each other.
There you go. Right. That's right. That's amazing. Amazing. Well, let's jump right into this and review where we are right now with the trial. I really enjoyed and learned from our conversation last week. We don't have our colleague Kamau King today, but hopefully he'll join us again next week. And if you gentlemen are available, we want to continue the conversation. We think it's an important conversation to have. And what's valuable to me as a journalist and communicator is the opportunity to connect with you, the legal minds, the practitioners, the educators, and explain in ways that our community, our culture finds sensible and digestible what is happening, the why behind what is happening, and what we can look at and expect in the future. So with that, I wanted to go to Clinton first to have you give us an update, Clinton, on where we are in the trial right now.
Well, my understanding is, the defense is rested. Derek Chauvin chose not to testify. He invoked his Fifth Amendment right to not do so. And from a strategic standpoint, I actually think that was a good call on the part of his attorney, that had he taken the stand, he would have been subject to cross-examination. And given how this case has gone down, the prosecution had a lot of material to work with, a lot of material. So, and I think when we spoke last week, I said that I thought it would be stupid if I were Chauvin's attorney to have him take the stand. So apparently, I don't know if he ever heard me say that, but he agreed, that was, but it would have been an interesting cross-examination. So now that both sides have rested, I'm probably what will happen tomorrow will be out of view of the jury. And that would be the lawyers are going to meet with the judge, go through the jury instructions. And as I've told friends of mine throughout this process, what's really going to be crucial in this case is the instructions that the judge gives to the jury. In other words, before closing arguments, the judge will tell the jury what they can consider, what they can't consider. He'll discuss what reasonable doubt means, and he will discuss, under Minnesota law, the prosecution does not have to show that Derek Chauvin's action was the only cause of death. The jury can find a guilty verdict if they believe that it was a substantial contributing factor, which is a standard I believe the prosecution has met, at least as far as the lesser counts are concerned. There are 3 different counts or 3 different charges he's facing: unintentional murder in the 2nd degree, unintentional murder in the 3rd degree, and manslaughter. And I actually think the top charge, which carries a sentence of up to 40 years, I actually think the prosecution has met its burden, and they've presented enough evidence to prevail. But ultimately, as I've said last week, and as I've told my clients over the years, you never know what a jury's going to do.
How does it look to you, Burnele? What's your sense of what you've been watching? I mean, I don't know if you watched this morning at all or not, but there was an interesting wrinkle this morning on whether or not the prosecution would, how the prosecution would address the issues brought up by a defense witness yesterday on the presence of CO2 or carbon monoxide in the body of the deceased. So what's your sense of where we are?
Well, I'm reading it pretty much as Clinton has indicated. He saw it. I had been a little less diplomatic last week in also agreeing that he probably was not going to take the stand. I said that if he took the stand, that would indicate an act of desperation. And so I think the one that says about where we are today is that he didn't take the stand, so he's not utterly desperate. The defense thinks that they at least have a chance. Under our system of justice, you almost always have, at least as they say in boxing, a puncher's chance. And I think that that's where he is. I think that what they are, what the defense is hoping for is that there's at least one juror who is going to hold out, and that this will end up being a mistrial. Because in terms of the evidence has been quite substantial. Mr. Collins has said that he thinks that he's met the prosecution has met the burden even for the highest charge. And while I am not a specialist in the criminal law area, my areas are government regulation, lawyer ethics, and constitutional law. So I have to try to stay away from a deep dive into the criminal law processes. But even I could get a sense that what's going on here is that a very strong case has been put on by the prosecution. But remember, the evidence is not weighed in terms of who had the greater volume of evidence, who brought in the most experts to say the most positive things in favor of their case. The question here will be, okay, you heard from the prosecution, now you've heard from the defense, and you have to decide, after listening to those two sides, who to believe with respect to the charges or the elements that have been charged in each of these counts. And so from that standpoint, all that the defense is looking for is one juror who will say, I have some doubt which rises to the level of reasonable doubt, and I just can't bring myself to view all the evidence as making it beyond a reasonable doubt that the death occurred in exactly the way that the prosecution has made out.
So, Clinton, when the closing arguments are made on Monday, how's that going to go? What's it going to feel like? What's it going to sound like? Are they going to be reading from scripts, or will they be? This is like stagecraft in part, isn't it? Now, how does it work? And this is a big case, and it's big because it's on television. And so everybody's watching it. Everybody has Perry Mason in the back of their mind as to how trials work. But this is a real deal, and real lives, have been in play, have been lost, and real futures are hanging on these arguments. What's likely going to happen? How do the attorneys, both the defense and prosecution, approach this important closing remarks on Monday?
Well, I guess first of all, both sides, but I would say especially the prosecution, you want to give the jury enough ammo, if you will, to vote your way without getting too deep into the weeds. I mean, you will have to go into some detail, but the way I've always approached closing arguments is I think to myself, what are my 3 to 5 strongest points? And you start off with the strongest point, and realizing that as the prosecution, you have the burden of proof, meaning you have to prove guilt. It's not that the defense has to prove their innocence. But what I would do, and I haven't practiced criminal law in years, most of my practice has been civil, but I think the same principle applies in that besides going through, even before I went through the facts that supported me, I would start off by thanking the jury for their service, acknowledging that it's an important trial and an important responsibility. And then I would really focus on what the judge's instructions were, particularly those instructions dealing with reasonable doubt. Reasonable doubt does not mean beyond all possible doubt. It means that is kind of hard to quantify, but I guess to make it easier, that you're like 80 to 85% certain. You don't have to be 100% certain. And that's something that if I were whoever's going to make the closing, since Jerry Blackwell made the opening, there's a good chance he's going to make the closing. Quite honestly, I don't know who's going to do it. But I would make sure, I would pound home the fact to the jury what reasonable doubt means, because the defense is going to try to make it sound like if you have a scintilla of hesitation, and that's not the law in Minnesota. It's not the law anywhere that I'm aware of, but certainly not here in Minnesota. And then if I made promises in my opening about what the evidence would show, I would go back and make sure that in my closing, I refer to those promises, because as the trial lawyer, your greatest asset or liability, depending on your point of view, is your credibility with the jury. And if they don't think you're credible, or that you've kept your word, or you haven't been straight with them, it's lost. So I would also try to emphasize to the jury, remember, members of the jury, beginning of this case.
No, we lost your sound.
Okay, can you
There
hear
we
me
go.
now?
Yep, there we go.
You would say the evidence, I promised you that you would hear 1, 2, 3, 4, 5, 6. And you've heard them all. You've heard Dr. So-and-so say this. You've heard this, that. You saw the video. Everything that we talked about at the beginning, you have seen has actually come to pass. So I would kind of weave that in with the judge's instructions. And then in the process of talking about your strengths, you would also address the weaknesses of the other side, or the things that they're going to try to show as being strengths. I mean, for example, you would say something like, now, defense expert so-and-so claimed Y, X, and Z. But as you heard on cross-examination, he had to admit this. He had to admit that. He had to admit this. So given all the evidence you heard from this witness, you can safely disregard what he had to say because it's inconsistent. And in regards to this expert, you heard him say this, 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 and on cross-examination, what happened? He backtracked here. He backtracked there. And so what you would want to do, kind of the overarching picture, is to make it clear to the jury, the evidence is overwhelmingly in your favor, the law supports your position, and the defense's arguments were weak and did not come even close to undermining the strong prosecution case you've put forward. Those are some of the general thoughts I would have as I would be preparing to make my closing. If I were on the defense side, I would, again, point out as many inconsistencies as I could from the prosecution. And I would emphasize that the case is for the prosecution to prove, not for his client. I mean, that his client, and again, the lawyers cannot comment on the fact that Chauvin chose not to testify. That's his Fifth Amendment right. And if whoever makes the closing for the prosecution were to comment on that, that could lead to a mistrial, meaning that they'd have to start all over. So they're not going to comment on that at all. But what the defense, again, will try to do is just to show there are enough holes or inconsistencies in the prosecution's position that it meets the court's definition of what constitutes reasonable doubt.
Burnele, what do you think?
I'm thinking about the police commissioner who is working with CNN to do a similar commentary to the one that we're engaged in. And I regret that I can't remember what his name is. I want to say some, well, I won't even try to guess. But one of the things that he said that I agreed with was, remember the O.J. Simpson trial. And remember how Johnny Cochran framed his argument. If the glove doesn't fit, you must acquit. He said, in this case, I think that I would be looking for some sort of a memorable summary phrase that I can hammer home. And just as Clinton has described, you've got to go through the judge's instruction. You can use that as a framework, but you can use some sort of phrasing that is memorable in order to set the tempo. And I don't, I'm not a criminal trial attorney, so I can come up with my own, but I couldn't help but think, you saw the need, believe what you see. You saw the need, believe what you see. And I would be hammering that thought home with respect to each of the witnesses, each of the key points in the elements of the case that I must persuade the jury. I don't think that I would leave the jury without any room. Well, I don't think I would leave them any room to avoid putting this case in the framework that I want them to put it in, to see the case from the perspective that I want them to have. You saw the need, believe what you see. And I think another thing that I would do, if it were allowed, and Clinton, you'll have to tell us whether this would be allowed. I would want to show, as the prosecution, that film, the video once again, and I would stop at one point and simply say, 9 minutes, 29 seconds. Let's just think about what that means. Mm-hmm. And then I would hold it for 9 minutes and 29 seconds before I spoke to the jury again. That's the amount of time that you got to consider. Was there any period during that time when the knee should have been removed? Because remember, he stopped breathing at a point when there were an additional 3 minutes of application of the knee. Mm-hmm. So again, you saw the knee, believe what you see.
Well, I think that's Commissioner Charles Ramsey that you're referring to, who was the former commissioner for Washington, D.C., and I think another state as well, I think Philadelphia. Or
yes.
But and so I saw that reference to how Johnny Cochran worked on behalf of his client. So that was in defense of a client. Do you think the defense in this case is going to be thinking along the same path, where they introduce some kind of catchphrase or some kind of language that creates and sustains, nurtures that idea of doubt occurring in at least one juror's mind?
Well, what does their case come down to? Their case comes down to effectively saying, there was so much going on, as their expert testified. There was so much going on that we don't even know what the cause of death was here, and somehow or other they've got to make that graphic for the jury. Sure, they brought in lots of experts. They had lots of testimony. You heard it all, but at the end of the day, there was so much going on that we don't really know what caused this death.
Would they buy that, Clinton? What do you think? You have to unmute again. Unmute.
Okay. It goes back to the jury instructions. Mm-hmm. And I think the defense would have more success with that approach if the prosecution had to prove that Chauvin's action was the sole cause of death. But since they only have to show that it's a substantial contributing factor, it's going to be a reach.
Yeah.
It's going to be a reach. I guess anything is possible. But as I've said, and I had predicted this from the very beginning, mm-hmm. that depending on the instructions and how the jury is instructed on what reasonable doubt is, and how they're instructed on how much of a factor Chauvin's actions had to be considered part of causing the death of George Floyd. And again, as I've said earlier, Minnesota law is that they only have to show is a substantial contributing factor, which is a much easier hurdle to clear than to show that it was the only factor. And I think the prosecution was very wise and very smart in being open and candid about the drug use and just putting it out there. It's much better for the prosecution to bring it up first because it gives you the opportunity to control the narrative. It's kind of like in the military, they say, you know, you want to fight the battle on the ground most favorable to you. And part of what that means from a legal standpoint is, you know, there are going to be hills and obstacles in the way. You don't ignore them. You take them head on. You address it starting with voir dire, to try to smoke people out to see how they feel about drug use and addiction. And then in your closing, you hit upon that theme more. And in our culture now, and I'll be honest, because more white people have dealt with opioid addiction in the last decade, it's become an issue in which the American population is far more sympathetic than 15 or 20 years ago, when it was perceived to be primarily a problem for dark people. And so I think that what the prosecution has done, again, very wisely, is just to put the drug use out there and to say, okay, he had drug issues. He was an addict. He was on and off the wagon. It's hard to beat, as a lot of people can attest to these days. But at the same time, you had this police officer who, by all accounts, there was some point at which, when Chauvin had his knee on his neck, that he died. And to pivot off what was said earlier in this conversation, but my esteemed colleague here, you saw it yourself. You saw it yourself.
Yes.
And these witnesses, the lay witnesses, even though one of them was an EMT, but generally speaking, you know, they're not medically trained professionals. They're lay people like you are. They saw the man was dead. I would really harp on that and make sure the jury understood what substantial contributing factor means. It means that it played a big part in his demise, and not that the other stuff maybe didn't. You know, you can really take a lot of the air out of the defense's balloon by, you don't want to negate the other stuff and say it didn't matter at all. But you could say, hey, we have something else that was far more immediate and far more devastating. And that's this knee on this man's neck for over 9 minutes.
Well, to confirm that too, or to support what you're saying and what Professor Powell is saying, the national commentators have been describing the video, the 9-minute and 29-second video, as the star witness. And so in that regard, Burnele, it would make sense, if allowed, for them to include that or highlight that as part of the closing argument for the prosecution. And I raised the question, as you were describing strategy, would the court allow a 9-minute and 20-second silence as a demonstration? What are the range of things that either prosecutor or a defending team can do to make their point? Is that something that would be allowed?
Let me jump in on that one.
Sure.
I think to have the jury sit there for 9 minutes and 20 seconds, the judge wouldn't allow. But what the prosecution could do is, during the close of their closing, say, right now it is 8:34 p.m. And then, you know, and then keep talking about various things, and then 9 minutes, 29 seconds later, said, okay, now it is 8:47 or whatever. Okay, that amount of time between when I said 8:34 and now it's 8:47 or whatever, that's the amount of time that Derek Chauvin had his knee on George Floyd's neck. So you could make the same point without having to ask for a pause. I can't imagine any judge allow you to eat up that much time in that way. But if you did it the way I described, there, even if defense objected, they would be overruled because they would, it's perfectly appropriate. There's nothing unethical or wrong about doing that, and it doesn't prolong the trial.
Yes. In my ethics class, I always point out to the students that it may be your case, meaning you as the lawyer, but it's the judge's trial. And the judge is going to have the final say about how his courtroom is going to operate and what's going to be permitted. But I think that what Clinton, the strategy he's laid out is an excellent one. I would ask, might it be possible to take the video and say, okay, at this point, the video shows this, and then proceed to describe what's going on, or to have some sort of engagement or presentation, and say, now we're at a minute in, and then pick it up again, constantly directing them to the video. That period of time was 9 minutes and 29 seconds. You saw the point at which I pointed out that he took his last breath, that our expert said it was at blah, blah, blah. And 3 minutes from following that is when you see the knee come off the neck.
Now that would work. That's, a variation of the same thing. That would work as well. Now, what I often do when I'm in that period when you're meeting with the judge and going through jury instructions, that kind of stuff.
That's like today, right? They're doing it tomorrow, I think, right? Tomorrow. They're meeting with the judge tomorrow, right?
Yeah. Well, yeah, they might even do it today, depending on when they finish, but there'll surely be discussions tomorrow. But what I often do, if I have any question that something may be objectionable, that's the time I bring it up with the judge and the other lawyer out of the presence of the jury and say, Your Honor, you don't have to give the entire story away, but you can just ask questions of the judge. Are you going to place any restrictions on the use of the video in closing? That's part of what this time is to be used for. So that if there's going to be problems, in advance, you can prepare for it, because you don't want to draw an objection, even if it's sustained, meaning or overruled. If the judge says this is a stupid objection, it still breaks your train and flow. It still breaks up the way the jury hears things. So an experienced trial lawyer, and the people on the prosecution team are highly experienced.
Yeah.
You have a pretty fair idea of those points that might be problematic. So if you're smart, you're going to discuss it with the judge between now and Monday morning, and make sure that everyone, yourself, the other lawyer, has clear guidelines and clear boundaries as to what they can and can't say.
It's also my understanding that the jurors are going to be able to submit questions to the judge, and the judge then will formulate an answer. He said after consultation with the lawyers. Is that a usual procedure in most states?
Well, at least in Minnesota, it's common. It's not unusual. I had a trial once several years ago in which the judge allowed the jury to ask questions directly to the lawyers. Now, that was unusual because you just don't know what's going to come out of their mouths.
That was civil, I assume.
Submitting the question to the court, to the judge, and then depending on the nature of the question, the judge might have to take a break, and there might be a little mini motion hearing between the attorneys and the court to figure out what's okay. Often what I have found during deliberation, in fact, I can assure you in a case like this, there will be questions from the jury to the judge, to the court during their deliberations. And what the practice of most judges I've appeared in front of is they take the question and then they get both lawyers on the phone and get their input in formulating a response. Because the worst thing that can happen to the judge would be to do something that would be the basis for an appeal. So if you can talk to the lawyers and kind of short things out out of the hearing of the jury, then you make the. I mean, there still is likely going to be an appeal no matter what happens in this case, but at least you can head off some of them by giving both lawyers a chance to weigh in on the question or to hear the question, and then the chance to weigh in before the judge tells the jury what they can and can't do.
Mhm.
Does the judge talk to the lawyers individually or both on the phone at the same time? He did say this morning, Clinton, that they would, as Professor Powell indicated, take questions from jurors. He'd get them, and then he would call on a Zoom call the attorneys. He said they didn't want to have to move juries back and forth because of the COVID-19 and all the technical challenges of any kind of proceedings right now. But in order to effectively facilitate jury deliberations, two things would happen. One is they would put a computer in the jury room with all of the documents, the digital documents, the videos, and they'd all be available there to be called up by the jurors if they wanted to review anything. He also said then that they'd have the ability to ask questions of the judge, and the judge would, he said he would talk to all of the lawyers, relaying the question, asking them their responses. What I didn't know is, does he talk to them at one time, or does he get team A and get their response, team B get the response?
No,
he did say he would make his own mind up, but
yeah,
he would have heard from
have
them.
everybody. I haven't had a trial since the Zoom era began, but back in the old days before COVID, the judge's clerk would call both lawyers and get them in a conference call.
Mhm.
And then once they were both on the call, then the judge would come in and say, we have the following question for the jury. So I assume they're going to do something similar here, that there's a question that they put to the court, to the judge. The judge's clerk or one of his assistants will get everybody on the Zoom call at once. And then he'll say, this is the question. I mean, because one of the worst things you can do as a judge is what's called ex parte or one-sided proceedings.
Mhm.
Whatever you say to one, you got to say to the other. And the best way to avoid that the best way to make sure that everybody hears the same stuff is to talk to them at the same time.
Got it. And so what will, how much time do the defense and the prosecutor get for closing? Say it's Monday. Is that going to be a 1 hour deal, a 2 hour deal, an all day deal? How's it likely to work?
They get as much time as they want. I mean, generally speaking, I mean, most judges are not going to limit you, but a smart lawyer knows that it is hard to keep people focused for much more than 45 minutes to an hour. Even that's a stretch. And so, I mean, it takes as long as it takes, but either side, you want to make sure the jury is alert and they hear everything you have to say. And if you drone on and on and on,
you lose people.
If in the jury's mind it sounds repetitive or redundant, then you're just, you might as well be talking to yourself. So I would say, if I were the prosecution, I would do everything I could to keep my closing to under an hour. I mean, if it takes longer, it takes longer, but I would have that be my objective. I think that given the nature of this case and the evidence, I think if you present it well, you can keep them pretty alert for an hour and they will hear everything, assuming you put it in plain English. But you start going much longer than that. I guess the one exception would be depending on how well you used audio-visual aids, the video and all that kind of stuff. But you don't want to be standing up there just droning on and on and on. So if I were the prosecution, I'm sure they're going to do this. They're going to, of course, show the video, and they can use graphs and diagrams and all that kind of stuff. Though the judge will likely instruct the jury that the arguments of lawyers is not evidence. And that even though they will have exhibits that they can take into the jury room with them or view on a computer, they don't get to see all the demonstrative stuff. I mean, they'll get to see the video because I assume that's been introduced into evidence, meaning that there's a formal presentation on the record, meaning in front of the court. You say, Your Honor, I'm presenting this as exhibit XYZ, and that the other lawyer had a chance to object or not object, and then it's received, meaning that it becomes part of the record. But if something doesn't go through that process, then it doesn't go back into the jury room.
And I would suspect that the judge will probably ask them, how much time do you need?
Oh, yeah, they would. Yeah, to get an idea for planning purposes.
Excuse me?
But typically that's not going to be asked in the presence of the jury, at least
Yes.
not in my experience. I mean, because if a lawyer in the presence of the jury says I need an hour and they go for 3, you're going to piss the jury off.
Yes, but the judge has indicated that he is going to talk with the lawyers about his responses. And I think at the time that the judge is talking about how he handles the questions from the jurors, that he's also going to be talking about at some point how he expects the closing of the case to proceed, and reminding them about the instructions and getting their comments and all of that kind of off-screen, I guess, inquiry that the judge needs, so that the judge knows what the case is about, how the case is going to proceed.
And one thing I would do, some judges will ask the lawyers, do you want me to instruct the jury first and then you close, or go the other way around? And my preference has always been to have the judge instruct the jury first. I think that's more effective in your presentation, because then you can say to the jury in your closing, as you heard Judge Cahill say, this is what constitutes X. As you heard him say about this, as opposed to saying, Judge Cahill, because you know what he's going to say because you have a copy of the instructions. But I just think from a persuasion standpoint, it's more effective to be able to refer to what they've already heard from the judge and to emphasize it, assuming it's favorable to you.
Mm-hmm.
So you're saying it's possible that the instructions will take place before the closing arguments?
Yeah, it could go either way. And typically, at least in my experience, and again, I'm talking as a civil lawyer, I haven't done a criminal trial in a long time. But at least as a civil lawyer, the judge will typically ask the attorneys, do you want me to instruct them first and then you do closing, or the other way around? And again, my preference generally is for the judge to instruct them first. And then I do the closing, just for the reason I gave, because at that point, then they've already heard the law and what they can and can't do and what they can and can't consider. And then you can make sure that your closing argument, to the extent that is advantageous to you, emphasizes those parts of the instructions that helps your case. And you're much less likely to screw it up because the judge has spoken. So it's easier to go back and refer to what he said than to say, the judge will likely instruct you X, Y, Z, even if you have seen the written instructions, because sometimes they deviate or things happen. And this way it protects your credibility more so.
Al, even though I'm your guest, there are 2 questions that I would like to put. And one of them is, and I'm not, I know this is not really a question, it's more of a concern. I'm concerned about this case because I think the prosecution has done such a damn good job of presenting it. I mean, they have really marshaled the evidence. They brought in articulate experts. The experts have been able to capture the attention of the jurors, by all accounts, coming from the reporters who've been part of the jury pool. I mean, been part of the journalistic pool covering the case. And with all of that, I'm concerned what may be the repercussions in the event that there's a hung jury, or that the jury even comes back and says, hey, we decided we're going to acquit. I mean, this is really a scary moment that we are about to come into. And so I just wanted to express that as a concern. I would hope that those who are following this trial, who've had concerns, really take into account that this is a trial, but a trial is a social, episode that carries with it a lot of risk. It's not the same thing as every individual making up their mind how things ought to be resolved. That's not the way trials work.
No, you're absolutely right. I agree with you, which is why, as I've said a number of times, I always tell my clients when I go to trial, you never know what a jury is going to do. And to prepare them for the possibility that even if your case is very strong, you could lose. I mean, I have won cases I should have lost and lost cases I should have won. But I think the prosecution has hedged its bets by bringing 3 separate counts.
Yes.
So even though that's a possibility, I think my personal view, the worst that happens is that he gets convicted of the least serious count. At least that's my hope. And I actually think, and I know that's why the prosecution, because initially there was some dispute as to whether they would be allowed to bring that manslaughter count. And it went up to up into the appellate courts before a final decision was reached. And I understood exactly why the prosecution did that, because often what happens in juries is compromise. And because I've talked to many juries after trials I've had, and there usually comes out to be 1 or 2 strong personalities on either side. And because most of the jurors, I don't want to sound too dismissive, are sheep, really. I mean, that the strong personality is often going to carry the day no matter what. And when I'm picking a jury, part of what I try to do during voir dire is to figure out as best I can who the strong personalities are. And then what you want to do throughout the case, and especially in your closing, hopefully you have the strong personalities in the jury are people that you wanted, and you want to be able to give them the ammunition to bring other people along to your position. And so, I mean, voir dire is as much art as it is science, because it's kind of hard. It's not always easy to determine who those strong personalities are. And often what I will do is try to figure out, again, along the same vein, who is likely to be the foreperson. And there are some people, as you're picking the jury, you can just tell either by the way they present themselves, their personality, or the questions, or how they respond to an voir dire, that they're more likely to be, if not the foreperson, at least one of the stronger personalities. And if that's the case, you want to make sure that if there are strong personalities, they are your guys and not the other side's.
I think that you're making the point that there's a good reason why most lawyers don't want other lawyers sitting in the jury.
Well, let me ask.
Will automatically defer to you.
Yeah, those are going to be the people that you automatically, say, well, thank you for your service, but we won't need you on this trial.
The question you raised, the concern you raised, Burnele, about this being bigger than the decision of 12 individuals because of the social impact, I think that's really coming into play right now because, as you know, since we talked before, another person has been killed at the hands of a police officer in Brooklyn Center. Brooklyn Center is a suburb of Minneapolis, about 10 miles from downtown. And in that case, a 20-year-old man stopped by the Brooklyn Center police ended up being shot and killed. And that happened on Sunday afternoon at 2:00 by Sunday night. Crowds assembled and disruptions began to occur. Those disruptions have continued Monday night, Tuesday night, and Wednesday night. And so the question is, what's likely to happen as a consequence of if something happens in this verdict that sparks anger. And I know the judge has said to the jurors, pay no attention to other things going on, that process does not involve this trial. But as humans, to me, it's looking like it's a practice run. This eruption in the past several days, I'm looking at as an observer journalist as an idea of what to expect if the society erupts like it did when the George Floyd killing took place.
I agree
Clinton,
with
what
you.
do you think?
I absolutely agree with you. I think to kind of paraphrase a common saying, the manure will hit the whirly metal blades, and not just here in Minneapolis, but across the country.
And so, what do you think, Burnele? I mean, is that where you were going with the question?
You hit it right on the head. When I said I had two concerns, my other concern related directly to the death of Dante Wright and the arrest of Officer Kim Potter, I guess it is.
Kim Potter.
And what I found so well, I'm not quite sure what the word is, unsettling about this killing at this time, at that location, is that while in the Chauvin case, the evidence is video, and it strikes me as rather overwhelming. In the Potter case, that is going to be a very difficult case to get a conviction on. Now, I know that she's been at this point indicted on second-degree manslaughter, and some have said, well, that's only preliminary, and it may be increased. It could be decreased, but it's, but we think that there's a real chance that other charges will be levied against her. I'm just not sure, however, that this is the kind of case, meaning the Potter case, in which you can expect to get a conviction. Reportedly, there have been about, 15 to 18 cases over the last decade or so in which the officers drew their handgun when they supposedly were trying to use their taser. But there have only been, I think, 3 or so convictions out of all those cases. I think that in that case, that the likelihood is that she is not going to be convicted. But I also think that much of the early discussion has been on the question of how could it be that she didn't know the difference between the weight of a taser and the weight of her weapon. This just doesn't make any sense. And there's been a lot in the public discussion that, quite frankly, I find coming close to demagoguery on that point. But there have also been a couple of cooler heads who have said, this case really shouldn't be about whether she made a mistake between choosing her taser and choosing her revolver or weapon. It really should be about the question of whether she was negligent in the first instance for reaching for any kind of weapon. But that's where the focus ought to be. But that's a case that we're going to have to deal with at some point, and maybe we'll be around the table discussing that one in a few minutes.
Well, the language I'm hearing often on both the Chauvin trial and I think we'll hear it in this one is continuum of care, I think. And what is the responsibility of an arresting officer to care for the well-being of the person that he or she is arresting? And I think it will get down to also discussing the use of force. When is force useful, usable, allowable? And how can interactions like this rise, as this one has, to the application of force, even if it was taser force and intended, but not delivered. Listen, we're out of time. This has been a great hour. Thank you so much. And I want to invite both of you back and others back to join this conversation next Thursday, if you're available. I think this is instructive for listeners, certainly is for me as a journalist and communicator. And I'm deeply, deeply appreciative of your insight and the analysis that you and we are providing in this important conversation. So, gentlemen, thank you so much.
Well,
thank you. Always a pleasure.
Yeah,
okay.
fun.
All right. We'll see you next time. Take care.
All right. Thank you.
Bye-bye.
Morning draws near, I rise and say my prayer. Little piece of bread to my mouth, little tea to wash it out. It's my daily tribulation, even though I'm a working man. I work so hard to make ends meet, with one suit and one shoe to my feet. Days are getting so hard, yeah, but I got to keep on pushing on this 9 to 5, working to stay alive. Working till sun goes down. As the sun sets in the west, I pack my things and head on home, thinking about tomorrow's journey as I try these streets alone. Searching for liberation, yeah. Got to step out of Babylon, take a step to Mount Zion. Days are getting so hard, yeah, but I got to keep on pushing on this 9 to 5, working to stay alive. Oh, on this 9 to 5, yeah, working till sun goes down, sun goes down. Oh, days are getting so hard, yeah, but I got to keep on pushing on this 9 to 5, working to stay alive. Oh, on this 9 to 5, working till sun goes down, sun goes down, sun goes. On this 9 stay alive. Oh, on this 9 to 5, yeah, working till sun goes down. Oh Lord,